We all make mistakes, right? Nobody's perfect. Mistake number one, not having a plan or having a very simplistic plan like just a will and thinking that's enough. 68% of Americans don't even have wills. But I would say even if you just have a will, that's not enough. A will does not constitute an estate plan. A will is just the absolute minimum. And in many cases, it doesn't help you. It exposes your estate to probate. If you have any assets, if you just have a will, your estate can be stuck in the California court system after you pass away. And very, very importantly, if you just have a will and think that's enough, it doesn't help you while you're alive. So mistake number one, what happens if you get into an accident? What happens if you have a long-term illness? What if you face dementia? Who can step in to manage your affairs? Who can make medical decisions for you? What would you want if you're in the hospital and can't communicate for yourself? If you don't have an estate plan in place, or if you just have a will, your family's going to have to go to the courts. They're going to have to get a conservatorship or basically a court order that allows them, that gives them the authority to step in and manage your affairs. It's a very expensive process. It's public. It's painful. You got to show the court what's wrong with you. It's not a good thing. And there are very efficient ways to avoid that. The three must-haves, and I added a fourth here that I'll address later. If you have over $150,000 or so in liquid assets, and or if you own any property, you need a revocable living trust. Everyone over the age of 18, regardless of how much they have, needs to have a durable power of attorney for finances, not just a check-the-box form. Ideally, it should be one that's done by an expert because it can address some other issues we'll address later. The power of attorney lets you name the individuals who can step in to manage your financial day-to-day issues, your business of life issues, dealing with retirement accounts, government agencies, the IRS, advanced healthcare directives. This allows you to name the people who can communicate on your behalf with doctors, with hospitals, and who can even make decisions for you, very challenging decisions with your guidance if you need that help, if you can't make medical decisions for yourself. I would add that if you have children and grandchildren, and if you have any assets, I would add a fourth key document, would be considering family protection trust for the next generation. Why a revocable trust is so much better than just a will? Well, if you have a will, when you pass away, your assets have to go through what we call probate. It's a public process in the California court system. It's expensive. The fees are set by statute. There's no wiggle room. They're very, very high. It's public. Anyone in the public can see us. When you see a celebrity pass away and all of a sudden you see every detail about his or her plans, James Gandolfini, former star of The Sopranos, when he passed away, everything was public because he just had a will. It's time consuming. It can take up to 2 years or more in some cases to get through the whole process before your loved ones get assets. And it's effective only at death. So creating a will, you name an executor, that person has no ability to help you while you're living. If you're out of it, they can't do anything. They're only empowered after you pass away to oversee this process. And if you have any property in other states, you would have a separate probate in that state as well. A trust, a properly funded trust, means that your assets go to your loved ones privately. They don't go through the court systems. The costs are half or less than the cost of a probate. There's no public access. It's quicker. Your family can really efficiently get through that process in about half the time of a probate. It can vary, of course. And really importantly, a trust lets you name backup trustees who also have the ability to step in and help you while you're still alive, but if you're incapacitated. So how do you fix this first big mistake? Well, you have to set up an estate plan. You need to work with an attorney who specializes in this area of law. You don't really want someone who dabbles in this. There are a lot of mistakes made, and you really want to make sure it's someone who can identify issues that are relevant to you beyond just the basics. Now, better to have a simple plan that's set up properly than no plan at all, but you want to make sure that you're addressing some of the other more sophisticated and challenging issues. Gilfix and Paul Associates, we are true pioneers in the area of estate planning and elder law. 40 years in Palo Alto. We're very proud of that. And we've served thousands and thousands of families throughout the state of California, from San Diego up to Wairika. So we've seen it all. We've served so many different types of families from all walks of life, from just normal everyday people to Nobel Prize winners and to CEOs, but everybody across the spectrum. And I love meeting people from all walks of life, and we can provide value really to everyone. We've saved hundreds of millions of dollars, if not more, in taxes for our clients. But most importantly, our mission and our goal is to empower you and to provide extraordinary value and peace of mind. We're very proud of our place in the community and our place in the legal world. Thank you, thank you, thank you check out other videos. I hope we get the chance to work with you, but regardless, I hope you got a lot out of this video. I'm Mark Gilfix. Stay safe and healthy.